So, all right, let's get started. All right, so please bear with me. This is my first time since we do not have our president today. So, good morning, ladies and gentlemen. I'm Carrie Baumgart, first vice president of the Colorado Motor Vehicle Dealer Board. Today's date is January 18th, 2022, and the time is 9:03. These proceedings are being recorded as part of the standard process of rulemaking by the board. I've determined that a quorum of the board is present, so it is possible to proceed. At this time, I'd like to call for a motion to open the hearing to consider proposed rule revisions related to 1 CCR 205-1 regarding motor vehicles and 1 CCR 205-2 regarding power sports vehicles. The board will consider proposed revisions to existing rules. The board will specifically consider proposed revisions of the following rules: Motor Vehicle Regulation 4420-121-3I, Power Sports Vehicle Regulation number 4420-423I. Is there a motion to open the rulemaking hearing?
Yes, I motion. This is Gordon.
All right, a motion by Ms. Gordon. Is there a second?
This is Ms. Behrens. I'll make a second.
All right, and a second by Ms. Behrens. All those in favor, Ms. Chandler did not show up, did she yet? Okay, we've got Mr. Flower.
Yes.
Mr. Shaughnessy.
Yes.
Mr. Tesfaye.
Yes.
And Mr. Walsh.
Yes.
All right. Let's see, is there any discussion? Nope, I guess I already did that, sorry. The motion to open the rulemaking hearing passes unanimously. Before we initiate the public comment phase, I will invite Ms. Rouse to explain the WebEx platform we are using and the process for signing up to make comments and or submit documents. Ms. Rouse?
Thank you, Madam Chair. Welcome, board members, stakeholders, and guests to this rulemaking hearing. We're using the Cisco WebEx platform for this hearing. Board members are panelists, and they can mute and unmute themselves as needed during the course of this hearing. Everyone else is an attendee. For those of you that are attendees and wish to testify during the public comment phase, there is a sign-up sheet located on our website. I would ask that you haven't already done so, please put your name on the sign-up sheet. The sign-up sheet will ensure that we give all that wish to comment the opportunity to be heard. It will also become part of the official rulemaking record. When we reach the public comment phase, we will use that sign-up sheet, and Ms. Hartman will let you know when you have been moved over and unmuted and can be seen and heard by everyone. When you've completed your comments and answered any questions the board might have regarding your testimony, Ms. Hartman will again mute your microphone and move you over. Thank you, Madam Chair.
Thank you. All right, the formal rulemaking hearing is now open. The hearing will proceed according to the provisions of the Colorado Administrative Procedures Act, specifically Section 24-4-103 of the Colorado Revised Statutes, and according to other relevant provisions of the law, regulation, and policy. Today's rulemaking hearing received official public notice on December 25th, 2021, by means of publication in Volume 44, Number 22 of the Colorado Register. Public notice for the Rule 4420-121-3I and 1 CCR 205-1 related to motor vehicles came under tracking numbers 2021-00802. Public notice for Rule 4420-423I and 1 CCR 205-2 related to power sports vehicles came under tracking number 2021-00803. Supplemental public notice took place through the publication of the websites of the Department of Regulatory Agencies and the Auto Industry Division of the Department of Revenue. Today's rulemaking hearing offers any interested person the opportunity to make oral comments to the board on one or more of the rules under review, or to provide additional documents for the board's consideration, or both. The hearing is quasi-legislative in nature, not adversarial. All viewpoints are welcome. Anyone can speak and share information and opinions regarding the rules under review. The board has before it the record for board review. Included in the record are the following: request for rule change from outside stakeholder. The current text of the motor vehicle related rule the board will consider in the rulemaking hearing, along with the red line text version and the clean text version of that rule. The current text of the power sport vehicle related rule the board will consider in the rulemaking hearing, along with the red line text version and the clean text version of that rule. Materials related to the three stakeholders meetings held on October 12th, 2021, November 9th, 2021, and December 7th, 2021. Filing and notice materials related to the Secretary of State's Office tracking number 2021-00802, motor vehicle related rule. Filing and notice material related to the Secretary of State's Office tracking number 2021-00803, power sports vehicle related rule. Filing and notice materials related to the Department of Regulatory Agencies filing under 1 CCR 205-1 motor vehicles. Filing and notice materials related to the Department of Regulatory Agencies filing under 1 CCR 205-2 power sports vehicles. Notice of hearing with proposed draft rules to the interested persons. Comments from the interested persons and the public received after the publication of the official notice of hearing on December 30th, 2021, and after. Ms. Beth Bellerberg, the subject matter expert and rules administrator for the auto industry, will introduce the record in general and then provide the auto industry division's position on the rule. The board will then entertain public comments on the rule. The board members may ask the division and any public commenter as many relevant questions as the board may have regarding any particular rule. After the public comments have concluded, Ms. Bellerberg will be permitted to comment further as needed on the rules. The board will close the public comment phase of the rulemaking hearing after the public comments and potential additional comments from the division have been made on the rules, and the board has it for consideration today. Once the public comment phase has ended, the board will enter into the deliberative phase, and it will not entertain any further comments from the division or from the public. During the deliberative phase, the board will engage in discussions and deliberate as long as necessary upon the written record for board review, together with any written materials made part of the comprehensive record subsequent to December 30th, 2021, written materials received after, and any written submissions received in the course of the board's hearing today. The board's deliberations will also include the oral comment of the division and the public made during the public comment phase. The board will deliberate on the rules brought before the board in the hearing today. The board will make some decision today for the rules. The board has options, including but not limited to the following. It may adopt the proposed rules as presented by the division, or it may adopt the proposed rules as presented by the division, but with modifications made by the board, or it may table the rules for consideration later in the meeting, or it may continue its deliberations on the rule until a later date that it announces, or it may reject the proposed rules as presented by the division. If the rule presented by the division are entirely new rules, then that new rule would not come into existence. If the rule presented by the division is a revised rule or a proposed deletion of a rule, then the rule in its current form continues in existence. After an action has been taken on the rule, the board will close consideration of that rule. The public comment phase of the hearing will begin now. Beth Spellerberg, who is the legal assistant and rules administration for the auto industry division and the motor vehicle dealer board, will make the division's presentation of the record to the board. Ms. Spellerberg, you have the floor at this time. Please proceed with your presentation.
Thank you, Madam Vice President. I first want to, thank our amazing stakeholders. They were passionate, hardworking. They took time out of their busy schedules to attend and participate in 3 rulemaking hearing meetings, working group meetings we call them. They provided draft language, we were provided with 8 different states' examples on the statutory provisions or regulations on vehicle availability and advertising. And one of our stakeholders even came up with compromise language to try to, proceed forward to get this rule passed, or not passed, but presented, where everyone could agree. So we received multiple requests from stakeholders to review advertising Rule 3 regulations for both motor vehicle dealers and power sports vehicle dealers as a result of the pandemic, global supply chain issues, and microchip shortages. We held 3 different rulemaking working group meetings that were well attended by the various stakeholders representing their respective industries to draft proposed rules to present to the Motor Vehicle Dealer Board today. I'm going to be repeating these same regulations, so in order to be more efficient, I'm just going to say the advertising Rule 3 for power sports vehicles and the advertising Rule 3 motor vehicle dealers, instead of like spitting out the particular regulation. So prior to the first working group meeting, the Auto Industry Division provided the stakeholders with the current language of both advertising Rule 3 regulations and the proposed rule changes from one of the stakeholders for the review and consideration. If you'd please refer to page RG2-21 in your rulemaking packet, you will see those changes. And what they are is they crossed out advertising and put the language in, it is misleading to advertise. And then in that same sentence, they added at the end, vehicle identification number. And then the last sentence, they added, a motor vehicle dealer may advertise vehicles for sale via the internet as long as the vehicles are in the possession of the dealer or are available to be shipped. And those same changes were made to the parallel regulation for the power sports vehicle dealers. And I'm not going to repeat those. You can just see that again on page RG2-21 of your rulemaking packet. So the working group meeting was held on October 12th, 2021 at 3 p.m. virtually via WebEx. And the stakeholders discussed the following language modifications. 1, extend period of time that dealers can advertise. 2, rule be amended to exempt from the requirement to advertise year and dealer stock number and expand requests to include VIN for advertising of trailers specifically over the internet. 3, amend rule to add available to be shipped. 4, to avoid inventory scraping, and that is where websites take inventory from other dealer sites and put it on their own. So to avoid that, change the time frame from 5 days to something else. 5, add to the last sentence, to the dealer from the manufacturer or distributor or their affiliate within a reasonable amount of time. 6, for trailers, add language, make, model, or SKU. SKU stands for stock keeping unit. And then 7, leave the language of VIN or stock number. So after all these issues and proposed language examples were discussed, not all stakeholders were in agreement to the language modifications. So we ended the meeting and we encouraged all our stakeholders to provide Auto Industry Division their proposed language modifications by October 29th to 2021 for the next rulemaking working group. We received all sorts of proposed language modifications from the stakeholders by that deadline, and the Auto Industry Division took all the proposed language and reviewed them internally and came up with a new draft of proposed language modifications to present at the next working group meeting. If you'd please refer to pages RG2-47 in your packet. here's the changes that we proposed based on the stakeholders' provided language. So we took out, at the very beginning of the 4420-121-3I, it begins with, advertising shall be construed to be misleading or inaccurate in the following particulars. So we took out the previous language that was suggested by a stakeholder. It is misleading to advertise because it is repetitive with the language at the beginning of the regulation. And we went back to the original language that was already codified. So we went back to advertising a specific motor vehicle for sale or lease with price or terms quoted without fully identifying the vehicle as the year, make, model, and dealer stock number. We then changed the format of the rule to add subparagraphs A, B, and C. And again, you can refer to page RG2-47 in your packet to what those were. We added B. The language from item B actually was taken from one of the examples that one of our stakeholders provided of those 8 other states' language, statutory language or regulations having to do with vehicle availability and advertising. And we kind of took some of the language from Oregon. And Oregon's language is found on page RG2-38. But we took away from their language the language about the special order and dealer trade language. So we added subparagraph B, which states, "The motor vehicle is not available for immediate delivery. The advertisement must clearly and conspicuously state the motor vehicle's availability, such as it is in transit or on order and that is not in stock." Then subparagraph C, we added some language about utility trailers, which is a very highly discussed issue in these stakeholder meetings. So utility trailers, as defined by section 42.1, 102, 111, and I'm going to define that for you per statute. Utility trailer means any wheeled vehicle weighing 2,000 pounds or less without motive power, which is designed to be drawn by a motor vehicle and which is generally and commonly used to carry and transport personal effects, articles of household furniture, loads of trash and rubbish, or not to exceed 2 horses over the public highways. So we added that language in subparagraph C, and we said utility trailers may use a stock keeping unit or SKU in lieu of a dealer stock number. And all vehicles may use a complete 17-digit VIN in lieu of a dealer stock number. And we looked at the parallel regulation for power sports vehicle dealers, and we again changed the beginning language because it was repetitive from the original language that's in the regulation. And then we added subparagraph B, which is again language from Oregon's example for us. And this was the proposed language that we sent out to all stakeholders in an email on November 5th, 2021, prior to the second working group meeting. The second working group meeting was held on November 9th, 2021. After a lengthy discussion, the stakeholders again were not in agreement with the proposed language modifications. So they decided to draft new language to address the year and VIN in trailer advertisements and the time frame for advertisements to be posted in both motor vehicle dealers and power sports vehicle dealer regulations. We encourage stakeholders to send Auto Industry Division their proposed language modifications by November 19th, 2021 for the next rulemaking working group, which is the third meeting. We took all the language that again was sent in, reviewed them internally, and came up with a third draft of proposed language modifications to present at the third working group meeting. This was the proposed language that was sent out to all stakeholders in an email on December 1st, 2021, prior to that third working group meeting. The third working group meeting was held on December 7th, 2021 at 2 p.m. virtually via WebEx. So what we did was, at this meeting, again, it was highly discussed. You know, these are pretty lengthy stakeholder meetings. And we changed the format to amend subparagraph C based on compromise language submitted by one of our stakeholders. We then added subparagraph D and E. So in subparagraph C, and if you can refer to page RG2-62, this shows us the proposed changes. So subparagraph C talks about utility trailers as defined by 42.1, 102.111, Colorado Revised Statutes, do not need to include the year if the trailer is less than 3 model years old. Again, that was a compromise language provided by one of our stakeholders. And then we added subparagraph D, which talks about material particulars. And I'll just, I'm not going to read this for you because it's in our packet. You can read it for yourself. But I do want to define material particulars for those that don't know what it is. So material particulars means those details concerning a vehicle for sale that are essential or necessary for a reasonable prospective buyer to know prior to making the decision to buy or not to buy a vehicle. And that comes out of 1 CCR 205-1, Regulation 4420, 121, 3H. I think it's like AD. So, and then we added subparagraph E, which states any motor vehicle may use a complete 7-digit VIN number in lieu of a dealer stock number. And we did the same changes in the parallel power sports vehicle dealers regulation, except we don't have a DRN because utility trailers do not belong under power sports. So what happened at this working group meeting, it was that for paragraph A, the working group concurred to propose change from a period of 5 days to a period of 3 days. I'll get more to that later. And then Rule 3, paragraph B, and this is for motor vehicle dealers. The working group concurred to modify the language to read, or otherwise in a specified location of the vehicle. And Rule 3, paragraph C, working group did not reach consensus with that proposed language. Rule 3, paragraph D, working group concurred with the proposed change, and Rule 3, paragraph E, working group concurred with the proposed change. So with a parallel regulation for power sports vehicle dealers, Rule 3, paragraph A, working group concurred with the proposed change from a period of 5 days to a period of 3 days. I'll get more to that later. And then Rule 3, paragraph B, working group concurred to modify the language to read or otherwise in a specified location of the vehicle. And Rule 3, paragraph C, working group concurred with the proposed change. However, after more discussion that was brought up again by one of our stakeholders, specifically with regard to Rule 3, paragraph A, the time period of advertising, we conclude the meeting by acknowledging that not all stakeholders were in agreement with the proposed language modifications to advertising Rule 3 for both motor vehicle dealers and the power sports vehicle dealers. So we concluded the meeting and just decided that we would send out the proposed language in the notice of rulemaking hearing, and we would allow people, our stakeholders and the public to come forth to this rulemaking hearing today and share their comments and feedback during this hearing. On December 10th, we filed the notice of rulemaking hearing with the Secretary of State's office website for both motor vehicle dealers and power sports vehicle dealers. Those are found on pages 66 through 75 in your packet. The same date, December 10th, we also filed a submission of proposed rule change, rule and statement and plain language of the subject matter or purpose of the proposed rule amendment with the Department of Regulatory Agencies website. Those are found on pages RG2-78 through 83. On December 15th, 2021, we sent out to all stakeholders the notice of rulemaking hearing with proposed rule for both motor vehicle dealers and power sports vehicle dealers. This notice advised the stakeholders that the rulemaking hearing is scheduled for January 8th, 2022 at 9 a.m. The stakeholders were also advised that the deadline to submit written comments is by 5 p.m. on December 30th, 2021. On December 30th, 2021, we received an email from one of our stakeholders with written comments regarding 1 CCR 205-1, Regulation 4420-121-3I, Rule 3 for motor vehicle dealers, and a request to provide oral testimony on behalf of their client. Please refer to pages RG2-102 through 106. On January 10th, 2022, after the December 30th, 2021 deadline, we received an email with written comments from another stakeholder. Since then, the stakeholder has since withdrawn their comments and no longer wish to have their comments considered at this rulemaking hearing. You can refer to pages RG2 107-111 for that stakeholder's email and comments. So if you refer to pages RG2 8 through 10 in your packet, I will then provide you, and what those pages are is the current language for Rule 3 advertising for both motor vehicle dealers and the power sport vehicle dealers. It also includes the red line version of what the changes that were made to the current language, and then the clean version, which shows the new proposed language that we're presenting to the board today. So while you're reviewing that, I'm going to conclude with the Auto Industry Division's position. Sorry. So while you're referring that, I want to tell you that the Auto Industry Division's goal is to provide simple, effective, and enforceable rules that do not adversely affect the industry's ability to be successful, but to keep the paramount issue of consumer protection at the forefront. That being said, the division supports the proposed revisions and find that the modifications do not impact the overall concept of what the division and stakeholders agree to in principle. That concludes my presentation, Madam Vice President. Thank you.
Thank you, Ms. Bellerberg. The division has finished its presentation of record, and it is time to hear comments from the public. If anyone in the audience has not indicated in the chat that they want to make a comment, please do so now.
Madam Vice President, we have 4 people who have asked to speak. I will unmute and move them over. The first one will be Nicole Brenner.
Okay. All right, Ms. Brenner, we'll have each speaker identify themselves by stating their full name and ask them to spell their name for the record. And because we only have 4, I've determined that it's not necessary to limit the time for each person to speak. So please everyone make your comments as succinct as possible.
Good morning. Can y'all hear me?
Yes, ma'am.
Thanks.
Yes.
Nicole Brenner with Reed Smith, speaking on behalf of Tractor Supply, and speaking to the changes to Rule 3, the advertising rule as to motor vehicles. I won't be speaking on any of the changes to the power sports vehicles rules, and will be speaking in support of the Auto Industry Division's draft, specifically supporting the changes as to utility trailers. So no positions to put forward on the number of days or timing of the advertising, but we'll be speaking specifically in support of the changes as to the SKU as an option in place of the dealer stock number, and the exception for advertising the year if the utility trailer is within the last 3 years of manufacture. So starting with the dealer stock number, which is the current rule in Colorado, the proposed amendments by AID would allow a dealer of a utility trailer, such as Tractor Supply, who I'm speaking on behalf of, but is similarly situated to other big box retailers of utility trailers, such as Lowe's. The SKU or stock keeping unit is what a retailer would normally use as a reference mechanism instead of a dealer stock number or a VIN. So a SKU would represent a type of product or a category of a product, but not the individual product itself. So to give an example, a SKU would represent all 5x8 utility trailers that weigh 900 pounds. And so on the Tractor Supply website, that utility trailer would be listed once with a SKU. Any change to that utility trailer, and as Ms. Spellerberg noted, that would be noted by a change to the material particulars that line up with Colorado's regulations, such as the addition of a taillight or something like that, would necessarily require the retailer to have a different SKU and list a different trailer. But what having a VIN or a dealer stock number listing would require that if a national retailer or dealer of trailers like Tractor Supply has 100 5x8 utility trailers in stock, we would have to list the same exact trailer 100 times. This is not something that we're required to do elsewhere in the country. As far as we know, it is an issue unique to Colorado, and is an issue that arises because trailers are captured within the definition of motor vehicles. And so that is why we're asking for this specific exclusion, so that the national website can comply with regulations across the country, and also hopefully not provide confusion to consumers who likely don't understand why they are viewing the same trailer 100 times on a website. So that is why we are supportive and appreciate that change being put in the auto industry division's draft. I also understand that some of the consumer protections that exist with a specific VIN or a dealer stock number relate to then going into a dealership and you want to protect the consumer from additional add-ons or upcharges. This would not occur with utility trailers. If you're not familiar, we're talking about an open bed utility trailer. Doesn't have a top on it. It's less than 2,000 pounds. It is something you could make in your own garage. There are no add-ons to be offered to the consumer. And so that consumer protection addition just doesn't exist here as to utility trailers like it would with motor vehicles. So I think that is, I'll try to be respectful of your time. Those are the general reasons why we are supportive of this change, and would respectfully ask you to make that change. We would like to be able to advertise and sell through our website to consumers. The last thing I'll point out is because the trailers are registered, the consumer still goes to the store and sees the trailer before they purchase it. So there is still that added level of consumer protection. And then speaking as to the model year, once again, this is something where trailers are captured in with motor vehicles. And I understand that for motor vehicles, the model year represents change. Motor vehicles come out one time a year, new models are rolled out. Those new models necessarily have changes associated with them year in and year out, and so you advertise by model year. That is not the case for utility trailers, and the manufacturer that we sell their trailers also spoke during the stakeholder process to this. They are manufactured on a rolling basis, 1 month to 1 month, and there's not necessarily a change in the trailer from 2020 to 2021. And so that provides no additional clarity or consumer protection, especially if you are using the SKU, which represents change. Adding the year does not represent change in the trailer. And so once again, for our national website, you'd be talking about the same trailer October 2020, and then another version of that trailer January 2021. I understand that there were some concerns during the stakeholder process with this exception, and so that was why we had offered the compromise as to 3 years. We are talking about new utility trailers, and so we didn't want to create a situation where trailers older than that might be able to fall within this exception. That wasn't what we were trying to do. And so we, for that reason, would ask you to accept the division's draft, which includes this exception as to advertising without the model year, noting that the SKU represents that change with the material particulars. I'm happy to answer any questions, but I appreciate your time today, and I appreciate the division's time and attention to a very long and thorough stakeholder process on this rule.
Thank you, Ms. Brenner. Does anybody have any questions for her?
And Ms. Brenner, this is Ms. Behrens. I have a quick question. So would a SKU be different, say, for the same exact utility trailer, even though nothing had really changed between the years, say, 2020 to 2021? Would those be two separate SKU numbers, or would it be the exact same SKU number?
If nothing has changed in the trailer from, let's say, a trailer manufactured August of 2020 to a trailer manufactured February of 2021, that would be the same SKU. It's considered the same trailer, and they just really are not treated differently like motor vehicles are. And if I can sort of give you a price point and just some information about the utility trailers, as Ms. Fellerberg said, we're talking trailers that are less than 2,000 pounds, open bed trailers that you might pull behind your pickup truck, something that you would put a lawnmower on. So from a price point and sophistication of equipment, we're talking something like your washer dryer or your lawnmower that you might also buy at a Lowe's or a Tractor Supply, for which the big box retailer is never giving you a manufacturer date.
Would it create any additional burden if there was a SKU that, as part of the SKU, just annually, it just got updated so that utility trailer always was identified with the year of manufacture? Because it seems like so now once that utility trailer becomes older than 3 years, how would somebody know what year it was manufactured if that SKU doesn't indicate in any regard what year it was manufactured? So
I think I'll answer your question 3 ways. So bear with me for a minute. So speaking to the specifics of the 3 years, as drafted, what I understand the rule to do is if the utility trailer is older than 3 years old, you would have to provide a separate listing online or in paper. So for the purposes of our website, then you need to list that trailer separately and note its manufacturer date. Second, as to clarity for the consumer and noting the year, because you do go into the store to pick up the trailer and register it, you get the manufacturer certificate of origin and you're able to see the trailer and see its manufacturer date. It is part of the VIN, it's stamped on the trailer, and it's on the manufacturer certificate of origin. So that information is always given to the consumer. They're aware of it. It's just not part of the advertisement. And then third, to specifically answer your question as to the burden as making it part of the SKU, the issue that we and other similarly situated large national retailers have is that like I said, the year and the MCO are with the trailer at the store physically. And so that information is literally not available to the person operating the Tractor Supply website. Because we have stores throughout the country, the actual trailers go there and they're shipped with their manufacturer certificate of origin. And our manufacturer also testified during the stakeholder hearings that they do not send us a central list of those manufacturer dates or of the trailers. And to be honest, in speaking with the people who operate Tractor Supply's website, our software system is not currently set up to list them separately by year. I am not sure, but that could be prohibitive of being able to advertise in Colorado and therefore be able to generate any sales through the website.
Thank you, Ms. Brenner, for that additional information.
Any other questions for Ms. Brenner? No? All right, Ms. Hartman, could you please tell me who is next to address the board?
Yes. Let me move Ms. Brenner back. The next person will be Jared Mullins, and he is now a panelist.
Right, and Mr. Mullins, if you could please speak your name and spell that, I would appreciate that.
Mr. Mullins, can you hear us?
I'm sorry, yes, I can hear you. Can you hear me?
Yes, now I can. Thank you, sir.
Hi, I signed up in the event that Nicole Brenner was not able to present before you. I don't have any additional comment. I think she summed it up very well. Thank you.
Oh, thank you, Mr. Mullins. Right, Ms. Hartman?
Let me move him back over. Your next speaker will be Mr. Dave Cardella, although where did he run to? There he is.
All right.
Mr. Cardella, you've been moved over.
If you could please spell your name for the board.
Good morning. Happy New Year. My name is David Cardella, C-A-R-D-E-L-L-A. I am the CEO of the CIADA Association of Independent Dealers for Colorado. I don't know if you can see me or not. Oh, let me go. Let me start the video. Okay. I am testifying today on behalf of our 1,125 members we represent. And I want to thank the dealer board for addressing these rules and these changes. We are in support of everything except the elimination of the years for the utility trailers. The utility trailer is a classified motor vehicle in the state. We believe it opens up a crack in the regulation that could be used by others to change disclosing the year if a model has not changed at all for the past 2 or 3 years. Could be used by a Tesla or a General Motors or a Ford if their model does not change. And there's a reason that they're designated by years because there is difference in the value and difference in the model. We appreciate where the utility trailers are or the big box stores are coming from, but regulations are put into place and they vary from state to state. And I'll refer to the material particulars regulation that we have in our state that protects our consumers and our dealers that does not exist in states that neighbor us. It is based off of the Spedding case. And that is was done to protect the public. And I believe that if you eliminate the year from being put into advertisements, that once the consumer arrives at the vehicle, does all the paperwork, gets the trailer hooked up, and then they get an MSO, and it's now not a 2022, it's actually a 2020 or 2019, that at that point in time, they just go on their merry way. When, if it was disclosed ahead of time, it would have been acknowledged, and I just would hate to see that door opened up for another bad player, let's say. Rules are put in not for those of us who do business the right way. It's done to prevent those who have intentions of harming the consumer to be able to do business in our state. So I am all for all the rule changes except the elimination of the year for a utility trailer, which in our state is classified as a motor vehicle. That's just kind of our position in short, and I appreciate it, and any questions, I'd be more than happy to answer.
Thank you, Mr. Cardella. Does any of the board members have any questions for Mr. Cardella? If none, then Ms. Hartman, can you please tell me who is next to address the board during the public comment?
The next person will be Matthew Groves. And Mr. Groves, you've been made a panelist.
Good morning, everybody.
Good morning.
Okay, I think we're good. I'll be very brief. My name is Matthew Groves, Groves, and I represent the Colorado Automobile Dealers Association. I apologize for the voice. I'm getting over some COVID myself. I just wanted to come to you guys today very briefly to express one long-term concern that we had coming into this rulemaking. We did not want to set up a regulatory structure where a manufacturer would be able to create one national inventory held in Michigan and allow dealers from multiple states to advertise the same vehicle going to the first person. Thanks to the diligence of the division staff and the multiple stakeholders around the table, we were able to avoid that here. This was probably our most intensive stakeholder meeting since off-premise permits back in 2017. So there was really a lot of work that went into it. We do appreciate everybody being receptive to the arguments and participative. In light of that, I think that CADA would support this change and would ask the board to do this.
Thank you, Mr. Groves. Does anybody have any questions for Matt Groves? All right, if none, then Ms. Hartman, do we have one more?
We do not.
Okay, all right. So is there anyone else from the public who wants to address the board regarding the rules being considered today? If so, please add your name to the chat box or raise your hand indicating your interest in speaking. All right.
No raised hands and no chats.
All right, Ms. Bellerberg, does the division have any further comments it wants to make at this time with regard to the rules being considered today?
No, thank you, Madam Vice President.
Thank you. We have reached the conclusion of the public comment phase of the rulemaking hearing. I'd like to thank everyone who has participated in the process today, and everyone who has otherwise participated in the rulemaking process to date for all their input and hard work. At this time, I'd like to call for a motion to close the public comment phase of the hearing to consider proposed rule revisions to 1 CCR 205-1 Regulation 4420-121-3I regarding motor vehicles, and 1 CCR 205-2 Regulation 4420-423I regarding power sports vehicles. Is there a motion to close the public comment phase of the rulemaking hearing?
This is Mr.
I would motion.
To close the public comment phase.
All right, so I have a motion by Mr. Shaughnessy and a second, was that?
Mr. Flower?
Okay. All those in favor, Ms. Behrens?
Yes.
Ms. Chandler?
Yes.
Ms. Gordon?
Yes.
Mr. Tesfaye? Is he still on?
Yes.
Oh, thank you.
Yes.
And Mr. Walsh?
Yes.
All right, thank you. The motion to close public comment phase of the rulemaking hearing passes. The public comment phase of the rulemaking hearing is now closed. No further comments from the public or the division will be allowed without explicit recognition by the president. The board will now begin the deliberation phase of the rulemaking hearing. I think we're okay. Rulemaking hearing, the deliberation phase is open to the public, but only board members and the Attorney General representative are permitted to participate without being asked a question by the board member or without being specifically recognized by the chairperson in order to add a clarifying or explanatory comment to assist the board in reaching the best possible determination. It is important that everyone remain silent during the board's deliberations. A deliberation phase will take place regarding both rules discussed. Today's hearing includes two rules, one motor vehicle related rule and one power sports vehicle related rule. Therefore, these will be the only two rules discussed. The board will deliberate the proposed rules and at the conclusion of the discussion, the board will vote on the rules discussed. The board members have in front of them a packet for the two rules at issue. Included in each packet will be a current version of each rule in the packet, the red line version showing the changes proposed for each rule in the packet, and the clean version showing how the rule would look if the proposed changes were all adopted. The deliberation phase is now open.
This is Ms. Chandler. My comment would be that as a trailer, under the trailer division, I don't think it's necessary to list the year because it has absolutely, it doesn't have to do with its, you don't have to upkeep it, you don't have to change the oil on it, you don't have to, have the year, doesn't really affect the parts and pieces of it. So I think for ease of advertisement and for compliance across the United States, I think it also could potentially keep Colorado less competitive in that area. So I just think it does make sense to leave the year off because it doesn't have all those components that a regular vehicle does. So I understand the idea that you don't necessarily want to be able to advertise something outside the state of Colorado or something that maybe doesn't have the same manufactured year. But I think just because it hasn't really changed the trailer itself, I don't think there's a necessity to advertise that year. So that would be my comment on it, but I think it's actually a rather helpful change and revision. So I appreciate the stakeholders and all that they've talked about and bringing that before the board.
Thank you. I have a question. Maybe some other board members can clarify this for me. I think, when I heard Mr. Cardella, when he spoke, he said that it would open up cracks for the actual automobiles to do the same thing if there was no change. And I'm not sure if there's some language in there that could keep that from happening. Is there any insight on that?
This is Mr. Shaughnessy. Just in our reading of the proposed changes, it looks like subsection C does have specific language that would prevent that proliferation of that definition beyond utility trailers. It specifically says utility trailers is defined by section 42-1-102 paren 111 CRS do not need to include the year if the trailer is less than 3 model years old. It's pretty specific and restrictive to utility trailers. And from my perspective, it appears that utility trailers in the state of Colorado definitionally fall under the scope of motor vehicles. But I think that we all recognize there's a pretty large difference between a Honda Accord and a utility trailer that pulls a lawnmower. And to just paint, the peanut butter approach of regulation to both is probably not appropriate there. And so I think the distinction to utility trailers is fair, and the reduced restriction for specifying a model year on utility trailers. The consumer protections afforded by specifying the model year of a motor vehicle like a car, a truck, an RV, the values between a 2019 and a 2020 and a 2021 are radically different. The utility trailer, the difference between a trailer manufactured in 2019 or 2020 is not radically different. And while I do respect Mr. Cardella's viewpoint that shouldn't spread beyond this definition. I think that as written, the stakeholders were thoughtful in restricting it specifically and defining it very specifically as well.
Thank you, Mr. Shaughnessy.
And I would agree with Mr. Shaughnessy and have no trouble with the proposed legislation. I think there was a lot of thought and effort that went into this, and I think the process worked itself out pretty well. So I would be in support of it.
I also think that as a car dealer, you would want to advertise the year because there is an advantage to having a newer vehicle. So that gives them an incentive to keep that regulation in check. But there is really no advantage for a trailer owner because, again, that product, there's not much difference between year to year to year. Whereas a car, you want to advertise the fact that it's newer and better and greater. So I just think even without that, I think the industry itself would say, no, we want to continue to comply. So I think that it's a very good distinction. And again, I support the distinction between those.
Thank you, Ms. Chandler.
This is Mr. Shaughnessy again. Mr. Cardella made another valid point that the rules are necessarily for the good actors, but to protect against, somebody that might have less than pure motives. And, I think it's possible that you could have a dealer that would prefer not to advertise a model year in order to mislead and make something appear like it's worth more than it is. But I think that the regulation as written does limit the exclusion to the model year only to utility trailers, which have a pretty narrow definition.
Ms. Behrens, I do have a question regarding, from a consumer standpoint, would they be willing to pay even just a small amount more for something that was manufactured in 2022 than a utility trailer that was manufactured in 2020? Because maybe they're thinking that that trailer's been sitting on a lot somewhere in storage on those tires and they've already got, they were manufactured 2 or 3 years ago. Would a consumer in their evaluation when they're looking online to purchase a utility trailer, would that impact the price they're willing to pay at all? Does anybody have input on that?
Ms. Behrens, this is Mr. Shaughnessy. In my experience, that's not a consideration for a product like this.
And I agree, as the consumer representative on the commission, I have no experience in the automobile dealer thing, so just hear this as a complete consumer. In my mind, as long as a trailer has all of its parts and pieces and it goes forward and it has all of the, and it's not rusted out and all of that, I don't think the year at all matters. As a consumer, you would already check the tires, you would do those things, regardless of what year it was advertised as or not. So I don't think that really has any bearing on it from a consumer perspective, at least from my personal choice.
Any other discussions?
Yes, please. If you give me the chance.
Absolutely.
Yeah, when these trailers comes to the auction, we really need to know what year is that trailer is, because a 5 years old trailer and a 2 years old trailer, they don't have enough value. The value is not equal like the other one. But the guy, if you don't put the years on, the guy can sell it as a 2021 when the trailer is at 1999. If he really cleans it up, it's going to be hard to know what year it is. And then when you sell it to the public, you really need to tell them what year it is. So I think the year is very important to put on the trailer.
So it's my understanding that they said the paperwork, it will always show the year of the trailer. So I think in all benefits, what I understood was that this is only for the advertising online for sale of the trailers. It has nothing to do with the auction or the actual paperwork that comes with the trailers. So am I correct in that? I mean, that's the way I heard it.
I believe that's
That's what I
correct
understand
as well.
My understanding was the same, that this is only in the advertising, and then when the consumer arrived for the purchase of the trailer, they would be given the manufacturer origin information, so they would know the year. I'm just curious if that doesn't give, like, I still am a little concerned that in the advertising process, that a 2020 trailer could be advertised at a price that is different than one that's in 2020, that was manufactured in 2021 somehow, and kind of, I think it's just unclear to the buyer when they're making their evaluation of what type of utility trailer or who they will be buying that from on their initial, purchase decision. Because when you show up to buy it, then it's so much less convenient to go, oh gosh, this is not manufactured when I thought it was. I didn't realize that this law had changed. I didn't realize that for the same price I could get something that was manufactured differently. And maybe we're talking about somebody who buys a lot of utility trailers and then resells them because, you know what I mean, like, for their business. Or they only keep them for a few years and then they update them or whatever for safety purposes or less maintenance or whatever. Like, it's just hard to tell. Like, I think having one SKU associated with an entire year of manufacturing wouldn't be that big of a burden to maintain as an advertiser and as a seller of utility trailers. That's my opinion, but I'd like to hear more.
Thanks, Ms. Behrens.
Madam Vice President, I would like to let you know that Ms. Brenner does have her hand raised.
Oh, okay. So are we allowed public comment to come back in, Ms. Rouse? I'm not sure how this works.
You are not, but if you have a specific question, which it sounds like the board does have some specific questions, you can ask Ms. Brenner to answer your specific question.
Okay. So Ms. Behrens, would you like to ask Ms. Brenner your question in regard to your concern?
Sure, I would ask, hi, Ms. Behrens again, just a question about, do you have a perspective on would it influence where the consumer would be making a comparison on prices of utility trailers of where should I buy my utility trailer from? And would it impact the price from the consumer perspective of when they were buying a trailer, would they pay more, slightly more for something that was manufactured this year versus 2.5 years ago?
Ms. Brenner, you've been moved over.
Thank you, Ms. Hartman.
Thank you for the opportunity to answer that question. Speaking on behalf of the industry, that issue was discussed in the stakeholder group as well. Discounting trailers by year or based on manufacture date, similar to what happens with motor vehicles where the new models come in and the older models get discounted, is not something that the industry does. It's just not something that happens, probably because the dealers are not keeping track of the exact manufacture date or exact year. They really are considering it the same type of trailer. And I think when you get to, basically now it's 2022 or it's September of 2021 and the 2020s getting discounted, that's definitely not what happens industry-wide. To your specific question on 2.5 years, that was part of why 3 years was the compromise that was put forward. When you get closer to that date, that might be a point when you start discounting a trailer that you still have in the industry. And so that was part of why that date was put forward. Within those 2.5 years, you would not be discounting a trailer right now, you can't even keep them on the lot, but I understand that that won't always be the case. Does that answer your question?
Yes, thank you, Ms. Brenner.
Ms. Behrens, this is Mr. Shaughnessy. I just did a quick search because I'm not an expert in this either. Utility trailers aren't necessarily my forte, but I looked at Northern Tool and Equipment, that's a large seller of utility trailers. And on their website, the websites are generally built around consumer demand. You know, we want to create websites that let people search on categories that are important to them. And year is not an option. This is a national website, so this is out. But I would assume that if consumers cared about the year, it would be listed there. The filters that are offered are the gross vehicle weight, the load capacity, the deck size, the wheel size, the coupler size, consumer rating, the brand, and the price. But year is not a consideration for this type of item. And that doesn't surprise me, I guess I would say.
Great, thank you, Mr. Shaughnessy.
Any other questions for Ms. Brenner? Any other board conversations regarding these two rules?
You ready for a motion, Ms. Baumgart?
Well, let's do that. Yeah, since so the board has now concluded the deliberation phase of the two proposed rules. The board will now vote on each proposed rule. First, we will vote on 1 CCR 205-1, Regulation 4420-121-3I related to motor vehicles. So there's, I'd like to call for a motion for a final or whichever adoption. So I think you all have the wording in your packets. Somebody want to make a motion?
This is Mr. Shaughnessy. I'd move that the Motor Vehicle Board adopt the proposed revisions to 1 CCR 205-1, Regulation 44-20-121 (3) related to motor vehicles as proposed and publicly noticed by the Auto Industry Division.
I second that motion.
Okay, great. So we have Shaughnessy and, all right. Any other discussion? With none, I'm sorry. No other discussion? All right, with none being, and Ms. Behrens?
Yes.
Ms. Gordon?
Yes.
Okay. Mr. Flower?
Yes.
Mr. Tesfaye?
Yes.
And Mr. Walsh?
Yes.
All right. Then it looks that the motion passes unanimously. 1 CCR 205-1, Regulation 4420-121-3I related to motor vehicles as proposed and publicly noticed by the division is formally adopted. Now, all right, the vote, okay, we will now vote on 1 CCR 205-2, Regulation 4420-423I relating to power sports vehicles. Is there a motion?
Mr. Shaughnessy, I'd move that the Motor Vehicle Dealer Board adopt the proposed revisions to 1 CCR 205-2, Regulation 44-20-420 (3) related to power sports vehicles as proposed and publicly noticed by the Auto Industry Division.
All right, do I have a second?
This is Mrs. Chandler. I second the motion.
Great. And all those in favor, or any other discussion? All right, all those in favor, Ms. Behrens?
Yes.
Ms. Gordon?
Yes.
Mr. Flower?
Yes.
Mr. Tesfaye?
Yes.
And Mr. Walsh?
Yes.
Right. And it looks, all right, the motion passes. related to power sports vehicle, 1 CCR 205-2 Regulation 4420-423I, related to power sports vehicles as proposed and publicly noticed by the division. The current, let's see, so I believe that's it. We have officially reached the conclusion of the entire rulemaking hearing. I'd like to thank the board members and everyone else who has participated in the process today. At this time, I'd like to call for a motion to close the hearing. Is there a motion to close the rulemaking hearing?
I motion to close, Ms. Gordon.
Thank you, Ms. Gordon. Is there a second?
I'll second. This is Luke Walsh.
Thank you, Mr. Walsh. Any further discussion? All right. All in favor, Ms. Behrens? Ms. Chandler?
Yes.
Mr. Flower?
Yes.
Mr. Shaughnessy?
Yes.
And Mr. Tesfaye?
Yes.
All right. Passes unanimously. So I declare this rulemaking hearing closed. I think at this time, it might be best that we take a quick break before we go into our regular meeting. Ms. Rouse, what do you think? Five minutes?
Yeah, that'll be terrific. That'll give Arlene a chance to redo the recording and get us started on the correct recording when we go into your regular business meeting. So thank